If you care about saving children from parental alienation, if you want to reform family court, or if you care about the destruction of our First Amendment rights, please listen. My name is Alex Baker, and I need your help to bring a constitutional challenge to the United States Supreme Court. Like so many other people, mostly men, I am a victim of California's unconstitutional law called the Domestic Violence Prevention Act, the DVPA. I've had my children taken away. My name was entered into the criminal database along with murderers and pedophiles. I've been gagged and disallowed from posting documents. And just what was my crime, my domestic violence? I won a civil lawsuit against my ex-business partner, who also happens to be my ex-wife. I made an internet blog where I posted court documents and I discussed the matter. Now, this emotionally upset my ex-wife, and under the DVPA, that is all that was needed for a domestic violence restraining order. Now, the DVPA also allows a restraining order where there is a threat of physical violence, and that's as it should be. We are not challenging that part of the law. But a DV restraining order can also be issued for any conduct that destroys the mental or emotional calm of the other person. Well, what does that mean? Or better yet, what doesn't it mean? Notice that this definition is entirely related to the emotions of the accuser, and it says nothing about the conduct of the accused. Would wearing an offensive slogan on a t-shirt constitute abuse if it genuinely angered the other person? What about using contraceptives that the other person considers immoral? Or what about voting for the wrong political candidate? Each of these hypotheticals could certainly disturb someone's peace, yet each is constitutionally protected, well, at least until now. Look, I have never done anything violent in my entire life, not to my children, not my ex-wife, not to anybody. The court in my case even found that my filing defense papers in the DV case itself was domestic violence. This law is wrong. A lawsuit is not violence. A lawsuit is the opposite of violence. A lawsuit is the right way to settle your disputes, and violence is the wrong way. This isn't just about me. This is about your civil rights. These unjust and unconstitutional restraining orders are being misused every single day in California family courts, in case after case, to gain advantage in property disputes, custody battles, and to perpetrate parental alienation. I do have the pro bono support of the fine civil rights attorneys at the National Coalition for Men, and for that, I am very, very grateful. We want to challenge the DVPA's vague and overbroad definition of abuse that gives judges unbridled discretion to violate our fundamental civil rights. The petition to the U.S. Supreme Court is drafted. You can read it by clicking the link below. But we cannot file this without your financial support, because the printing costs and the filing fees total nearly $5,000. I've been fighting this case all the way through the California courts for 2.5 years. I'm tapped out. Please donate what you can. This is urgent. Our filing deadline is June 24th, 2019. if you care about parental alienation, if you care about civil rights, this is your chance to make a real difference in the real world. Don't forget to share on your social media. Thank you.